This is the Court Leader's Advantage, a podcast series for court professionals and by court professionals. Brought to you by thecourtleader.net and in cooperation with NACOM, the National Association for Court Management. Civil filings are falling. They have been so for some time. In fact, most court filings have been on a slow decline. In 2018, the National Center for State Courts put out a bulletin stating that nationally, every major case category had declined from 2008 to 2016. There are indications that in some states, California for example, the decline in civil filings started as far back as 1980. This gradual decline seems little affected by economics, court organization, the presence or absence of court self-help centers, the state of the local bar, the type of case management system the court uses, or the amount of filing fees charged. With the possible exception of Texas, this decline seems widespread. This inevitably leads to the critical yet unanswered question, why is this happening? I'm Pete Kiefer, and welcome to the Court Leader's Advantage podcast series. This month, we're talking about a new book just out by Alan Carlson and John Greacen entitled, What is Happening to State Trial Court Civil Filings? We'll explore questions such as, why didn't we court professionals see this coming a long time ago? Are there changes in our society that are leading to changes in how people view the courts? Do we have any idea how people are getting their disputes resolved if it's not by coming to court? Are courts actually ready to do the work to find out what's happening with filings? And what advice do our panelists have for courts that are facing this decline? Here to discuss these questions are Alan Carlson, retired court administrator for the Superior Court in Orange County, California; John Greacen, nationally known expert on courts and court administration; and Marcus Renkensmeyer, Deputy State Court Administrator for the Arizona Administrative Office of the Courts. Thank you all for joining today's podcast. John, you and Alan analyzed civil filings in 5 states, but you also had a number of findings that had more universal implications. Can you put your book in context?
The most universal context is that we as court administrators in our entire careers have known that filings always go up. And so we always expect that we will need more judges, more staff, more automation, bigger courthouses. And it turns out that's not true. You asked the question, why did we not recognize it? We just weren't paying attention. But the context of our study is this, that we asked 5 states, California, Minnesota, Ohio, Illinois, and Texas, to give us data going back from 2018, when we started this work, to the time that they last changed the way they counted civil cases, so that we knew we had consistent data over whatever time frame they reported to us. So we ended up with data sets that went from 41 years in California to 16 years in Illinois. We also, to provide a nationwide context for this, looked at the database maintained by the Court Statistics Project at the National Center for State Courts, with the last year being 2021. That was the last year for which they had reported the data at the time we started writing this up. We looked at that data set from 2013 to 2021, an 8-year period. And what we found was that total filings per capita for all of the reporting states, which were 42 or 43 in each of those years, had dropped from 2013 to 2021 by 36%. Total filings per capita nationwide. In terms of civil filings, which was what our study focused on, the drop per capita filings nationwide was 26% over that time frame, that 8-year time frame. Now, the rest of the details of our study, which we will talk about to some extent, focus on these massive data sets that the 5 states provided to us. And we looked into that data to the extent that the data descriptions and categorizations allowed us to.
Now, your book states that although there have been ups and downs, this decline in civil filings has been trending for years, maybe decades. You also state, and I quote, "Our experience suggests that most judges, court administrators, and lawyers have little or no notion of the phenomenon we observed." How could we have all missed this critically significant issue for so long? Alan?
Yeah, I think the the point to look at is we didn't really miss it necessarily one year to the next. And when some of the states, as in California, were providing funding based on filings, we would notice, oh, we're getting less money this year than last year because our filings went down. I think the big thing from the study is we didn't look long-term. So we really missed the fact that over 40 years, it had dropped a lot because we were only looking at 1 or 2 years at a time. I think when people look at filings, they think, well, that's just input. Not particularly important. Yeah, we measure them because the administrative office wants us to report them, and okay, they get used to determine weighted caseload or funding. But it's more than an input measure. I think one of the things that comes out of this study is we have to start treating filings as a performance measure. How are the courts doing? Because if filings are going down, notwithstanding growth and population, something's going on there. And that we need to start looking at that.
John?
Let me give you one little morality tale that comes out of our book. We cite to a California study conducted from 1960-61 to 1991-92, a 30-year period. During that time frame, the absolute number of filings increased by 150%, or an average of 5% per year for civil and family filings. That became the knowledge. That was the fact of life. And it was true over that 30-year period. And that's a significant period. The research was very good. It was correct. But life changes. And as the study in California shows, in our 41-year time frame, the total filings declined over those whole 40 years by 21%. And the per capita filings declined by over 55%. But our definition of the world was defined by that earlier 30-year study. And the moral of the story is we have to keep re-examining the reality of our processes. What was true in the past is not necessarily true now. And of course, the most important conclusions of all this are that the nonsense about frivolous filings and the massive overload of the workload of judges is completely undercut by this data from more recent years. There is no cascade of frivolous filings there because the filings are going down.
The irony of that study was that it was a Futures Commission study.
Yeah.
And it happened to occur at the peak, right before the peak of filings, which nobody subsequently paid any attention to. Well, now we have data. We have to start paying attention long term.
Marcus Renkensmeyer?
My sense is, first, I agree. Everything I've ever done in my career has been based on a growth model, right? And we've always used those filings, and that was maybe the foundation for new buildings, new staffing, and just our whole mindset was sort of built around that paradigm. My sense is right now that we've got this imbalance when we think about the unrepresented litigants and in the court system, and my sense is that that's growing. Okay, where folks just are even scared to come into our judicial system because they find it so difficult to navigate the system. And you've all heard about barriers to justice, I know. Okay, but think about it for a minute. The location of our buildings, the kind of strict business hours, the cost of litigation, just getting started in that process. And so I think Ellen is correct. I think folks have maybe decided I can't navigate that system, not even going to try to come into the court system. And so we have this huge group of folks that are not served, or maybe they're underserved, right? And I would mention too, I don't think it's just in the civil arena. I think this would spill over to family court and maybe now the probate courts, some mental health cases as well. So I think it's a very broad scope dynamic that we really need to kind of really get focused on this.
The Legal Services Corporation does every 5 years a justice gap study.
Mm-hmm.
And the most recent one showed that 92% of low-income Americans with civil legal claims got no help or inadequate help for those cases. That's a 92% failure rate, or filings that should be that are there that aren't.
Yeah, my sense was I was thinking about the multi-door courthouse in Washington, D.C. years ago, and that model was that there would be triage right at the service counter before filing, right? And folks maybe could get some help in the neighborhood mediation or that type of thing. Others would need to come into the court process. My sense is now these folks are not even coming to the court, okay? Even though we've got all these digital portals now, and we've tried to increase access. Many states have a commission on court access, and so that's terrific work, right? But I think John is right. We've got a huge number that are just never going to set foot in our court system, and yet they have legal needs, certainly legal disputes and those type of things when it comes to think about housing and of course all the civil litigation that needs to be dealt with.
Your book references a 2007 California Judicial Council study on small claims that I found intriguing. Let me quote. Many parties to small claims cases in the study appear unable to identify their legal dispute with very much specificity. This led me to 3 questions that I would like to ask each of you individually. Alan, the gap between rich and poor continues to grow in this country. In response to the previous question, John referenced the Legal Services Corporation survey that found that 74% of low-income households had at least one civil legal problem, and that 92% reported that they received inadequate or no legal help. Now, blue-collar people with demanding work schedules and modest incomes have not the money, the time, or the emotional energy to hire expensive attorneys and repeatedly appear in court. Have we priced the working class out of our courts?
Yes, but yes, the price of litigation may be too high. Those same studies that you referenced say that most families don't even have $400 in savings, and a lot of filing fees are $400 in bigger courts. So they can't even get started. But I think it's more than pricing. You also mentioned they're busy. Marcus mentioned about courthouses, getting access to courthouses, the hours, the courts only are open the days they have to work, the times they have to work. But I think that more of an issue is what those findings say, and there's others, one by the California Bar Association, one by the ILS folks, saying people don't even understand that they have a legal problem. Well, if you don't even know you have a legal problem, you're not going to go look at the court to figure out how to solve it. And then even those who figure out, oh, maybe that's a legal problem, somebody tells them the court might be able to help them. They go to court, and notwithstanding some great self-help stuff that we've developed over the years, it doesn't quite work. They don't understand what their legal issues are. They don't understand what evidence they need to present, and they have troubles navigating the process. And we've made inroads with self-help programs, but we clearly need to work a little more on that and spend more time with people saying, so why didn't you even come to court? Or, okay, if you came to court but you left, why couldn't you go to the next step? What do we need to tell you and help you with to get the next stage in the process? So it's not just pricing, it's the whole structure, the whole way it works doesn't work for a lot of people, and it's not just low income.
One of the most dramatic findings from our study was the very significant decline in the number of small claims filings across almost every state. Illinois was an exception, but that was explained by the situation in Chicago, where there were historically very few small claims filed. And over the time of our study, the filings in Chicago increased, but when they got then to the state level, average level, they too started to decline. So if you look at just our chapter on small claims, you find complete support for what Alan just said. You raise the jurisdictional level for small claims. You create all these self-help programs to help people use small claims. They're not being used.
And the filings keep going down, even if you raise the limit, even if you provide more help. That was the decline in small claims was the most staggering decline we saw of any case type. And it was really disturbing.
We were intrigued by that in Arizona because there's been some discussion about perhaps changing that jurisdiction limit. And then when I looked at the long-term impacts there, it sounds like that really did not bring more folks in, let's say, into the limited jurisdiction court, where you thought it might be a little bit easier pathway for those folks. But
no,
that's really instructive, but at the same time, very concerning.
John, courts are an adversarial system. Therefore, businesses, often being one half of the equation, are naturally looking for an advantage. In years past, they have used compulsory arbitration built into contracts, schemes for foreclosing on homes without having to file a case, and selling debt to collection firms, all as ways of staying outside the court system. For years, we have assumed that there was really no reasonable alternative to courts for resolving disputes. Are litigants increasingly able to avoid court in ways we have not envisioned?
Alan and I tried very hard to restrict the conclusions we drew in this book to the data that we had available to us. And we were unable to get comprehensive data on some significant issues like the ones you raise of the use of mandatory arbitration clauses under the Federal Arbitration Act. And there are experts who do say that they think that has had a very large impact. And all four of us know, when we look at consumer contracts these days, they always include that kind of a mandatory arbitration clause. So, but we don't have the data to support that.
Mm-hmm.
We also know that debt buying is something that has arisen in recent years, where firms buy uncollected debt from hospitals and banks and mortgage companies for pennies on the dollar. But that does not change the legal obligation of the defaulting debtor. The defaulting debtor still owes 100 cents on the dollar, even though the current purchaser only paid 3 or 4 cents on the dollar. Plausible explanations, but we can't say that they produced the filing decline.
The other problem is that you never know how many cases went to arbitration that might have gone to court, but they went to arbitration because of an arbitration clause. And the American Arbitration Association people, they don't publish much data on how many cases they have. So it's hard to know whether they're a significant portion or a minor portion of that. I saw some data on ODR resolutions once, but it was out of context. You didn't know whether it was, there were 10 cases and they resolved 3, or whether there were 4 cases and they resolved 3. So it's hard to know what happens. If you are diverting cases before they even get filed, then we never see them in filings, and there's really no way to count them to do that. And the arbitration clause can be in a lot of contracts. There's also in employment contracts, and their contracts also contain non-dispute or non-compete clauses, and that reduces filings, but it's hard to know how many. There are a lot of cases where people say that their employer is cheating them out of money, but they can't go to court to collect that because of the way the law is written, or they should be entitled to overtime, but they're not getting overtime, although there's some federal work to change that. So there's lots of possibilities where their cases are going somewhere else, but not coming to court, but we have no way of counting those. We have no way of knowing the volume of those sorts of things.
And this would be a whole nother research project, but I wondered about some of the work going on with administrative agencies, right? And so you mentioned employment law, Alan, but think about all the other areas of assistance and whatnot. And perhaps that's the good thing. Maybe that's a better arena, but
Maybe.
It would be interesting to trace back, 50 years and with the data that you folks have collected and see if that might be one of the dynamics at play.
Marcus, by definition, some litigants are regular court customers. Debt collection firms and property management companies serving as representatives for landlords can routinely appear in court, often against self-represented defendants. Does this routine relationship between the court and these types of entities create a power imbalance, particularly regarding self-represented defendants? And might this contribute to the decrease in the public's trust and confidence in courts?
Well, Peter, I think that is true, regrettably, and I think that imbalance may be kind of growing. Hard to document, hard to prove that. That said, I was thinking about this a little bit, and I think courts have really tried to step up when it comes to procedural fairness. That is, I see a lot of the judges and the staff really trying to guide folks through this process of litigation. So I go back to the first earlier discussion to say these folks that we're talking about, the unserved, are just not even coming into our system. And perhaps that is a function of their trust and their confidence, but that's the group I'm really concerned about. I think once folks are in, we do our best, and I think it has improved to guide folks, through the self-service centers and kind of our forms that we've made available, that type of thing. So it's kind of a mixed bag in my mind here. And you mentioned relationships. I think the courts are pretty careful, not to have any kind of unseemly relationship, let's say, with the collection agencies and others. And I think we're pretty careful there to try to hold that appearance of, just an independent judicial branch that would provide fairness. And so that's been the effort, I know, in a lot of the work that I've seen across the state courts.
I think the basic problem is that by trying to be impartial and appear impartial, we actually create an imbalance. If the two parties don't come in with equal representation, it's unbalanced. But how do you create a balance when you're supposed to be neutral? I think that's a fundamental issue. We didn't discuss that in the book, but it's a fundamental issue with our justice system, is how can you create a balance when the system, by the way it's designed, the procedures require each side to have representation by lawyers who know what to do and are following the law, so to speak. It's a dilemma. I'm not sure how you solve that.
There are a number of publications, including one that I put together for the Institute for the Advancement of the American Legal System, entitled Ensuring the Right to be Heard, that talk about ways that judges accommodate the needs of self-represented litigants by treating them fairly, but not necessarily equally with represented clients or sophisticated debt collectors or the like, or landlords.
The book states, methodologies that use raw filings to estimate the number of judges or staff or the amount of funding needed by a court are at best trailing indicators and inherently flawed. Yet, to be cynical, in my experience, arguing for more resources has been the main reason why we collect that sort of data. Now, the book recommends a series of changes for collecting more detailed statistical data. Many of these recommendations would have little or no effect on a court's resource allocation in future years. Are courts actually ready to do the work to find out what is happening with civil filings, even if it may not help them or could even hurt them fiscally? Alan?
Yeah, I had kind of mixed feelings because I have worked on weighted caseload studies probably since the 80s in California. And I would start out by saying, look, they're better than nothing. Having said that, they're not really good for much, in my opinion, because by the time you collect the data and analyze it and come up with new numbers, it probably takes about 2 years. So now you're already 2 years old on the value of the weights. If you start applying those weights to filings, any change in the filing mix can mess up the totals. If you have a general number for personal injury cases and you suddenly have a bunch of asbestos cases, the number is going to be wrong. And then the weird thing is, I thought about this later. So if our standard is we're supposed to complete most cases within a year, you want 90% of your cases resolved in a year, and your case weights don't reflect, your resources don't reflect the case weights until at least the second or third year, it's way off kilter for doing things. And then the other thing is the categories. And the book recommends that we need to have more detailed categories. I think one reason is for weighted caseloads if you're going to use those things. But I think the other thing is we need to have better case data that allows us to analyze whether changes in legal procedures or court decisions or substantive law that the legislature does really makes any difference. Because we have several examples in the book where changes in legal procedures that everybody assumed would affect case filings didn't. In fact, the delay reduction stuff in California, there was a reduction in filings of exactly the middle class types of filings that you would have expected to be benefiting from the delay reduction program. It had exactly the opposite effect. So we need to start collecting better detail and more accurate data on filings in order to better manage our caseloads. And jumping ahead a little bit. So how do we do this? I've been working with a couple of vendors because I think that one place where artificial intelligence might be valuable to the courts is we may be able to develop AI tools that can look at a filing and say, this is this kind of filing. It's a personal injury involving an auto accident and it's just 2 people, or it's an auto accident involving a person and a trucking company. And who's got lawyers and who doesn't have lawyers and how many parties are involved, things that we don't collect now because we don't have the resources to collect data like that. But I think that using tools to analyze filing documents, particularly if they're e-filed in PDF form, would allow us to start having the kind of abilities to impact our operations, to analyze what works and what doesn't work. So to me, that's one of the big things going forward. And it, ironically, is a place where artificial intelligence of a certain type might be useful.
John?
Pete, let me give you just an example of where the data is unhelpful. California divides civil filings into unlimited civil and limited civil. And the dividing line is 50K in ad damnum, the amount requested. So you know that most of the evictions, most of the small contracts, most debt collection are going to end up in that limited civil. But you don't know what proportion at all of the total limited civil is in any one of those categories. So how do you figure out what's going on if you don't have data finely grained enough to let you determine the answer to that.
I
Marcus?
know with our Arizona civil case filing sheet, they ask the attorneys or the filers to go ahead and designate the categories, and there are probably about 15 categories. And to John's point, the other category, I believe, makes up 25–30% of that caseload. And I always care what's in that, and can we kind of further differentiate and whatnot? And so, such a good point. And I think that's likely the same case maybe over in the family court and other areas as well.
And that's why Alan's idea of using an artificial intelligence tool to conduct the analysis is so much preferable.
So what advice do you have for court professionals tuning in today and facing the future specter of declining civil filings? Alan?
I think I already mentioned the categories issue. We got to find a lot more categories, and the ones that are relevant to case processing, to whether or not people file, to how they navigate the system. I think the other thing is we have to start paying attention to filings over long term, which this study says have changed in ways that we weren't really paying attention to. So you need to look at that. There's one chart in the book, I think, that says if you pick a year and say, okay, how have filings changed in 1 year, 5 years, 10 years, 40 years, the numbers vary widely. Sometimes it went up, sometimes it went down, and it's all about what year you picked and how far back you go. So we have to be more attuned to that and then look at the whole thing over time in that sense. I think along those lines that we need to make filings a performance measure. That's an odd concept to say that your input is a performance measure.
Yeah.
But as we point out in the book, every business, the performance measure is what are your sales? How many products did you sell? We don't do that. We treat that as, oh, that's just something that happens and we'll keep track of it. But if you have to start saying, why is my performance measure going down? And it's a performance measure, but then I think we're going to have to start paying attention to a lot more things than we have before. And the other thing, and this is hard to do on a one court by one court basis, even for a big court, is we got to start talking to our litigants or potential litigants. We got to start talking to people, say, why are people not coming to court? Or where did you get stuck when you started to look at the legal system? And how do we loosen that part up? It's really almost against our values to say we need to talk to potential litigants to one side of the case, for example. But I think somebody needs to start doing that so that we can do a better job for everybody and improve access to courts.
Yeah, I think if you stay with that private sector analog, then every business also wants to know how many consumers do we have? How many customers do we have? What's our price for customer acquisition and whatnot? And we've just, I guess I've never thought about it that way, right? So I'm just very fastened on the case filings.
John?
I would raise another caution. And going back to that story about the 30-year California study that was accurate, but only for the 30 years that it covered. Our study is accurate, but it only is good for the period we studied. And we cannot assume that filings will continue to go down just because they're going down. In the book, we say that the pandemic creates a discontinuity in the data system. That there's a before COVID, there's an after COVID, and the court system is different after COVID. I'm afraid that was wishful thinking. Bonnie Huff and I have just completed a study in Texas that pointed out that remote and hybrid proceedings in Texas are going away. That's not the case in places like Arizona and Minnesota, where the Supreme Courts have put their thumb on the scale and said, we strongly favor continuing remote appearances. But we just cannot continue to be blind men and elephants. We have to continue to study and track what is actually going on. And the closer we can get to real time, the better it will be for us and our citizens.
Marcus?
And then Peter, you were asking about advice to court managers,
Yeah.
obviously the management field generally. And I think inadvertently, we've just kind of conflated case filings with workload, right? And so if you think about the family court for a minute, where we did a little study years ago in Maricopa County, and we found that 50% of the judge's workload was post-dissolution, right? Folks coming back to court on child support and custody and the like. And we never reported that data. We never used that with the county board for funding and whatnot. And so I think it's going to require, I think, our next generation to look at the kind of the throughput, some of the intermediate parts of the court process. The family court is just one, but I think about the problem-solving courts and how the court is the hub and the convener and all that time and energy we spend working with the other agencies, likewise in mental health and whatnot. So we may have a good story to tell in some of those areas, but I think we need to dig much deeper there and probably be much more systematic about that kind of approach. And my sense is that the bench may welcome that, okay? But it's going to take some really good thinking to kind of put that together. And it might be some work that would maybe even supplement when you think about court tools and some of the other terrific metrics we have, but to say, how can we expand that out and try some other approaches here?
I want to thank Alan Carlson, John Greacen, and Marcus Renkensmeyer for their analysis, their observations, and their recommendations regarding the challenges of declining civil filings and the crisis that it presents to our courts. If you'd like to purchase a copy of the book, the link to the ABA bookstore is on the screen. It is https://www.americanbar, that's all one word, .org/products/INV/book and /438-284-365. The link is also in the additional resources section on the podcast webpage. As always, my thanks to you court professionals tuning into today's episode. Whether it's the mysteries of declining civil court filings or the complexities of new technology, you always face each new challenge professionally. Thank you. Join us on Tuesday, July 16th for another episode dealing with the issues facing our courts. This has been the Court Leaders Advantage podcast series. I'm Pete Kiefer, and thanks for joining us today. Thanks for joining us today. The Court Leaders Advantage is a regular podcast series on courts and court administration. Today's episode will be available on our website, on the Court Leader website, on YouTube, Facebook, iTunes, LinkedIn, and on X, formerly known as Twitter. Become part of the conversation. If you have questions, comments, or ideas for future episodes, email us. Our address is podcasts@nacomnet.org. Did you hear an interesting comment by one of the panelists that you would like to listen to again, but you don't want to search the entire episode to find it? The additional resources section of the webpage has a question time marker sheet. Find the discussion question on the sheet, and next to it is the time that question was asked. You can quickly fast forward to that time and listen to the panelists' comments. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leader website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.